So yeah, hi, I'm Ben Warner. I lead product marketing at Bravado.ai. I'm excited to lead today's webinar. Really just introduce today's speakers. So yeah, I'm here with Nick Fuller and Darren Abernethy. I'll let you both introduce yourselves.
Awesome. Thanks so much, Ben. Hey, everyone. Good to meet you all. My name is Nick Fuller. I lead Fuller Consulting. We're privacy technologists. So we focus on this exact intersection of legal and technology. And when it comes to CMPs, how do you deploy them properly? How do you maintain them? What's the right digital governance that goes into these platforms here? So looking forward to the conversation. Darren?
Terrific. Thanks, Nick, and thanks, Ben. Very happy to be here with everybody. We know you can be anywhere, and we appreciate that you're here with us. My name is Darren Abernethy. I'm a partner shareholder at Greenberg Traurig, an international law firm of 2,700 attorneys. I work out of our San Francisco office. I counsel companies of all sizes, from startups to Fortune 50 companies, on, about 7 days a week on building privacy programs, on compliance with different regulatory regimes in the US and around the world. I specialize in digital advertising and ad tech. Advertising technology matters, but I'm involved quite a bit in federal and state investigations, privacy litigation, mergers and acquisitions, and privacy and security and M&A, things of that nature. So it's a fun and varied practice, as no doubt the folks who signed up for this webinar know very well. And I'm happy to have a nice discussion today about the latest in this area.
Thank you so much, Darren and Nick, for joining us today. I'm very happy to have you. I'm getting both the legal expert here and then someone who's more of the privacy consultant practitioner. Has helped a lot of customers deal with these privacy issues related to consent management on websites, apps, and so on. So I'll kick us off. So today we're talking about why consent management platforms need continual privacy risk monitoring. So the status quo is that most websites now have CMPs implemented, but the reality is most websites are still not compliant. So that's kind of the theme of like today of how we can resolve that problem. Um, Before we get started, yeah, please do ask any questions throughout the session. You can submit them in the Q&A. We'll try to answer them during the session. If not, we'll get them to them at the end. Um, Also, this session will be recorded, and we'll send out the recording and the slides afterwards. And also, to give the legal disclaimer, this is for informational purposes only and does not constitute the provision of legal advice. Okay, with that, I'll get into this graph slide I previewed earlier. So, yeah, I pulled some data on a lot of the increasing enforcement we've seen in the US over the past 4 years. On the left, maybe this is no surprise, CEPA lawsuits have really led the charge in terms of privacy litigation. And from the data I looked at and looking at Fisher Phillips, they post a tracker on CEPA litigation. It looks like there's about 7,500 lawsuits that have been filed over the past 4 years, and many of them are handled privately, and a lot of them are simply just threats of a lawsuit. So those have uh, really taken a lot of the time and concern of privacy teams across the country. VPPA. So this one also has seen recent spikes. So these are lawsuits related to companies that are streaming video, and then they share the video viewing data, and that falls under a federal law. And there's been several high-profile, large sum settlements over the past few years, ranging from $1 to $20 million. And then the FTC and CCPA, we've seen those enforcements come down. In the, Over the past 4 years, the FTC was really focused on health data that was shared without proper consent. Those for both web and app situations. And we've seen those increase over the past several years. And then particularly this year, we've seen CCPA fines rise. We've had three CCPA fines just in the past 5 months, with Healthline being the largest, just about 6 weeks ago.
And Ben, I would say, just to add one note onto that, what I think the takeaway of this slide is that there is enforcement and attention on this area, both from individuals and from regulators. You have SIPA on here, the California Invasion of Privacy Act, which we'll talk about in a moment, sort of a wiretapping call recording statute that you see in a number of states that require consent for certain things. Otherwise, it constitutes eavesdropping or interception of communications. You got the VPPA, the Video Privacy Protection Act, federal law. These laws have private rights of action that allow individuals to sue, and you've seen the plaintiffs bar, massively increase their lawsuits, as we'll talk about in a moment. But you've also got, the FTC and the CCPA, federal and state. In California's case, the California Privacy Protection Agency, the only state privacy regulator in the U.S., and they have been initiating fines and enforcement action too. So to me, the real takeaway is just in the last few years, we've seen companies getting hit from both sides, both from private litigants and from regulators who are taking an interest in this area. And so it's just ratcheted up the amount of attention and the need to get things right.
Yes, thank you, Darren. That provides a lot fuller context on all three of these types of, actually four types of fines. Stepping back from more of a global view, so we've seen, since GDPR, really launched the whole privacy space in 2018, there's been a cumulative 5.65 billion in GDPR fines, 2.36 million per fine. This year, I think we had the largest GDPR fine ever. Meta had one of the largest in 2023 for a data transfer violation. There's now over 150 countries with privacy laws. I believe that the stat is something like 80% of countries have privacy laws now. We just talked about the CCPA enforcements over the past 3 months. And yeah, including the CCPA, but FTC as well. They're looking at, and other states looking at dark patterns. The GDPR is also looking at the same thing. When you say dark patterns, that it's the websites and the apps and any form that companies have to collect consent are misleading. Maybe the buttons are not there. They're forcing people to either not take action or to provide consent. So we've seen a lot of enforcement globally just over the past few years. So yeah, going back to what I was stating earlier, so this is some research we did end of last year using Privado's web auditor tool. So it can scan any website and check to see any of the compliance requirements are being followed. Most notably, are the websites honoring opt-out signals in the US, and in Europe are websites honoring opt-in consent. And in the US, we found that looking at the top 100 websites, 76% of websites do not honor CCPA opt-out signals, and they average 69 compliance risks. In Europe, it's about the same, 74% non-compliance for opt-in consent, with a lot lower number of risks, about 23 risks. So each risk would be number of times data is shared when it should not be shared because someone has not provided the proper consent. So we've got this imbalance here. We've got consent management platforms implemented across the board, and all of these websites have the consent management platforms. And their goal is to collect and manage consent according to the privacy regulation, but most all websites are not compliant. So, how can we get around that? So that's what we want to talk about today. And I'm going to hand it over to Darren to continue the conversation.
Great. All right. Well, thank you, Ben. Well, I think from our perspective, maybe what makes the most sense is to try to do sort of a 30,000-foot level to step back to say, hey, why are we even having this webinar today, and what's really the thrust of it? And I think the idea is that what we're starting to see in some of the different enforcement actions, of late, in particular in California, where the California Privacy Protection Agency, the CPPA, enforces the CCPA, the California Consumer Privacy Act, but we see this in other jurisdictions as well. And what we're starting to see is there's more of a focus on the technical implementations that businesses and website operators and mobile application operators use to control consumer preferences in relation to cookies and other tracking technologies and software development kits, SDKs, things of this nature. And so, the consent management platforms, CMPs, these are often the vehicles that websites use, sort of vendor provided tools that allow for capturing consent or using cookie consent banners, different sort of functionality that you have to manage the cookies that you want to cookies and tracking technologies that you want to be accessed that you want to provide access to uh, your IP address, your information identifiers, things of this nature. And so what we want to do is say, look, CMPs, in and of themselves are not the problems. This is very agnostic as to individual CMPs and even the necessity of CMPs. It's more, let's look at what's going on in the regulatory space to see what things you need to be on top of in relation to your use of CMPs and what other sort of corollary tools are there out there, such as that Bravado and others offer that can help. And so I guess the first question is, why now? Why are the compliance risks so widespread, as you can see on the slide? And the answer is, CMPs are maybe asked to do more sometimes than they are designed for. They're designed to manage consent. They're not there as compliance verification mechanisms, although they sometimes, facilitate this by having for instance, a time date stamp as to when somebody consented to a particular user interface or notice that they were presented. So that's good, but that's not sort of verifying compliance in and of itself. What else is going on? We've got websites and mobile apps that change constantly, and they update. They're living creatures in some ways. And so if you're not on top of your CMP or the tools that you use to capture consent and control the cookies and the JavaScript tags and things like that on your website and your apps, then you've opened yourselves up to potential risk. There's also, we see with clients, and I'm sure Nick can speak to this as well, there's often issues where, the left hand doesn't know what the right hand is doing in some cases within a company, and what team owns the use of the CMP compared to the use of a tag manager, compared to the use of non-cookie related technologies, conversion APIs, social media companies sometimes use as a non-cookie solutions. All of these things come together, and sometimes they create confusion or silos or lack of understanding of who's responsible, and then things fall through the cracks, and then a regulator cites to your incorrectly configured CMP or consent tool in an enforcement action, as we've seen pretty recently here in California. And other things, dark patterns, deceptive having the CMP set up in a way that doesn't allow for neutrality or sort of capturing someone's actual choices. We also have, of course, more regulator attention than ever because the laws have evolved, and now, whereas we were used to in the European Union under the e-privacy directive and the local implementations of that law, you have to get opt-in consent, if you will, for any information that's going to be stored or accessed on an end user's device, their phone, their hard drive, etc. We have a different regime now in the US where under a number of state privacy laws, we have opt-out rights if someone is selling or sharing the personal information to a third party for the third party's own use or for an targeted advertising purpose. Cross-contextual behavioral advertising is one of the terms used. So there's all this going on. So we need to kind of adapt and evolve and make sure the websites are set up the right way. You've also got more tools available to both you and to regulators to check websites and see what cookies and trackers are on there. How are they responding to signals that we set from the browser or even just opt-out requests through a CMP? So this is happening more than ever. You've got daisy chain issues where one tracker can let on other trackers and you didn't know that. And you didn't have, you have responsibility for it on your website, but you didn't know that that was there. You didn't have a direct relationship with that third party because a different tracker entity, third party, let it on the site. So there's all of these things going on, and it creates sort of a new world in terms of how we deal with this. And you've got, of course, typical issues that you see in the screenshot there. But what if the banner doesn't load correctly, or a reject button isn't visible, or it's not configured the right way to talk to the tag manager, and so you request an opt-out and it doesn't happen. We'll go next slide, please. And so that's at a high level kind of what's giving way to some of the attention that we're seeing and some of the enforcement actions. Sort of broadly speaking, what are these here? You've got invalid consent issues, sometimes with pre-check boxes or cookie walls that may not work for a particular jurisdiction where they have certain rules. We talked about Europe being effectively more of an opt-in for tracking technologies and cookies that are not strictly necessary, or effectively essential for the website or the mobile application or the OTT device or whatever screen it's being displayed on, it needs to be essential for that site or application to operate from the perspective of the end user, not the company. Every company would say, yeah, if we don't have advertising cookies on our website, we're not going to make enough money, we're not going to survive, so it's strictly necessary. But the GDPR and the regulators' interpretations of this is pretty clear that it's not based on the business's perspective, it's based on the user's perspective. So like load balancing cookies would be strictly necessary, video, certain, you know, fraud prevention, security related cookies, these are all essential for protecting the individual, but they might not be, they're not usually for targeted advertising cookies, or in some cases, third-party analytics cookies, things like this. So consent is key now that we have new regimes in the US here, including federal, in terms of the use of pixels and the law. Ben referenced the VPPA. We'll talk about that in a moment too. So consent is at the heart of this, and being agile, depending on your market, is key. Dark patterns, deceptive consent interface design, putting a thumb on the scales of getting the consumer to do something you want it to do, you want them to do, based on how you set things up, which is even explicitly indicated in something like the California Consumer Privacy Act and the regulations, that if you use dark patterns, it's not effective consent at all, and it would vitiate the consent that you think you have. Unauthorized third parties, daisy chaining we talked about, tracking without consent, having things load and not affording people the ability to opt out, or somebody requests to opt out and you don't honor it, then you have a problem. Sensitive data sharing, that's certainly always an issue, and sometimes there are special rules that apply based on the state or other jurisdiction that would require you to get opt-in consent before you collect, and use certain sensitive data for ad targeting or other purposes. And then session replay tools and chat bots and social media pixels we'll talk about in relation to wiretapping and call recording statutes, because they also separate legal regime and statutory framework, but same idea of notice and consent, and the plaintiffs bar trying to make hay out of taking legacy laws and applying new internet technologies to them. We'll go next slide, please. Well, and let me stop and see if Nick has anything there from his perspective, or to continue.
Yeah, I think it's clearly there's a lot going on in this space, and it's almost can feel like it's too big of a mountain for organizations to climb. How do we keep track of the 12 different things these regulators and private rights of actions and these states are putting upon companies? One thing that I've seen in when it comes to like sensitive data, so I was speaking with a large grocery retailer yesterday, and what they've been working through is, in general, they're not collecting really sensitive data, but on certain checkout pages, when it comes to say feminine products, that starts to become that sensitive data. So they need to, on those specific pages, figure out how do we stop tracking only on those pages, but we want to track on the rest of the kind of these sites, so we're not collecting or sharing data that falls under those sensitive categories. So it brings a lot of complexity for organizations, especially ones that don't necessarily see themselves as technology companies. Now, it's common to say, oh, every company is a technology company today, but it's truly getting to the point where if you want to participate in global commerce today, you need to figure out, how do we do that? How do we advertise to folks? How do we collect the data that we need? How do we do it in a way that drives consent? And you brought up, Darren, not just web, but also you mentioned mobile, you mentioned OTT, so your CTV as well, like apps on your television through Roku and all that. That starts to bring another level of complexity, especially when you have an authenticated state for these consumers. So you log onto the website, all right, yeah, I know it's Nick on the site, and Nick set his preferences, don't sell or share the data, but I also have a mobile app for my site too. Uh, well, what we're seeing a lot from our customers is the preferences expressed on the web, you know who I am, that needs to be shared across device. And so I also want to stop the selling or sharing of data happening in the mobile app, because mobile apps have SDKs similar to, like, best analogy is like a cookie, but inside the mobile app itself, we need to disable those, or opt out of the tracking and sharing that might take place on the mobile app. So again, just more of this complexity that makes it really difficult for organizations that this was not top of mind when we started to build this landscape. And so that's a lot of what we're seeing here today.
Totally agree. Yeah, that is what I'm hearing in conversations as well, and it's being reflected in some of the enforcement actions, which we'll talk about in just a moment. And so maybe that's a good segue into, Nick and I and others and Ben and others put our heads together to see, in terms of the conversations we're having, what are some of the most common misconfigurations that we are seeing with clients or out in the wild, and that regulators are picking up on and starting to mention both in their guidance and in their enforcement settlements. And those include, what you might expect, which is to say, number one, sort of miscategorized trackers or uncategorized trackers. And so, you have a CMP that will oftentimes the service includes scanning your website, we'll say, and it recognizes certain cookies or other tracking technologies or scripts, and it will indicate to you its recommended default categorization for those cookies or trackers. And that can be right, or maybe it can be wrong. Sometimes it's a matter of, it's not as simple as, it's not black and white because it depends on the underlying contract that you may have with the third party, that would limit their ability to use, retain, or disclose the information for other purposes, and so that gets at least for US and some of the state privacy law perspectives, really it's doing an analysis of whether a cookie is selling or sharing in nature and the relationship the company has with the third party, and if there's a contract in place that limits this from a data processing addendum perspective or a service provider addendum perspective. But we just see all sorts of issues with things being miscategorized or not categorized at all if it's not recognized by the CMP database. So that's something to always be aware of is, no matter what, I would say don't accept at face value just whatever is sort of spit out by default. It needs to be tailored to your website, your privacy program, your contracts with the third parties or the vendors slash service providers slash processors. And so to be on top of that, because, that could be the ball game right there. And we've certainly have seen this in some of the early enforcement actions under the CCPA, for instance, about not only, as we'll see, not honoring opt-out, signals, opt-out preference signals, but also not correctly categorizing cookies or not treating cookies or trackers as sale and opt-outable that they should have. And so that's partly, at times due to miscategorization, misunderstanding of what it is, or not classifying it at all, but it's still on your site and you're still responsible for it. Another is sort of pixels and SDKs that fire before the CMP. If you're using an opt-in approach and they fire before, or if they continue to fire after somebody submits an opt-out request through the consent management platform, obviously a common issue, obviously cited in a lot of cases. Tag manager misconfigurations. This is where you use a tool like Telium or Google Tag Manager or Adobe, others that sort of act as a technical layer between the website and the CMP, where it controls the behavior of the tags on the JavaScript tags on the website, the ad tags, things like that. But sometimes if the CMP isn't talking to the tag manager or your website isn't talking to the tag manager, if there's some break in the chain, you once again have issues where you appear to be affording an opt-out right or an opt-in right to an individual, and they think that they're doing so, but actually on the back end it's not working, and you're still responsible for it. Yeah, as Nick mentioned, pixels and SDKs that are implemented on web pages that collect sensitive data have to be very careful and very selective about that, and be very intentional and mindful about it. If you're doing anything that has arguably sensitive information under the applicable laws where your consumers or end users or customers reside, then you have to take into account, is it something like California where you have to afford a right to limit the use of the sensitive data to the primary purposes for which it was collected, and not any secondary purposes, or not to infer characteristics about somebody? Or is it like some other states where you have to have an opt-in with any sensitive personal information, including if you're going to use it for ad targeting? So you have to be careful when there is sensitive data that can trigger those special categories where you're very selective about where you put the pixels, how it's shared, is there consent, some sort of mechanism that captures consent before you do so. et cetera. We already kind of mentioned the jurisdiction-specific privacy requirements in terms of having reverse IP lookup to, derive where you think somebody is from, even though that's technically speaking not the laws themselves don't indicate how to determine residency. Usually it kicks it out to a state tax code, something like that. But making sure it's configured for different states and jurisdictions. And then another common issue is sometimes there's multiple laws that you're trying to solve for. The California Consumer Privacy Act, as we mentioned, is largely an opt-out law for people over the age of 16. But California Invasion of Privacy Act, CIPA, there's different interpretations as to how to comply with that, but one that's commonly used is, well, for any of these social media pixels or other VPPA type pixels that share certain information with a third party, arguably, or the plaintiff's bar would say, maybe for that one, maybe we want to do an opt-in supported by a notice just for that particular type of pixels, but we want to maintain an opt-out for our broader third-party CCPA selling and sharing cookie compliance, because that's not doesn't have to be an opt-in. That could be an opt-out, or you can use global privacy control and honor it in a frictionless manner, and that counts as a do not sell. So there's different there's different laws and frameworks that are kind of colliding here that create implementation issues, and sometimes CMPs, if you don't know how to direct them, or configure it in a certain way, you're not solving for it in the right way. Other areas we'll move through quickly here. We'll talk more on the next slide about sort of global privacy control, recognition of opt-out preference signals, very important stuff. We've got discrepancies between privacy policies and cookie policies and the CMP setup. So opens up to potentially, deceptive statements where you say one thing, but it's not supported by the technical mechanisms on the site. That's a problem. Treatment of non-cookies is sometimes an issue with CMPs where they're focused on cookies, but in fact, it's not, the way that the CCPA or Virginia, other state, Colorado, they define personal information much more broadly than just cookies or cookie IDs. There's different things. So, legacy trackers being on a website, daisy chaining where you let other cookies on. These are all areas that we see that are not necessarily solved for and show up as compliance issues. Yeah, and I think we'll do next slide on that, please.
I'll take this global privacy control. And if I have a lot of background noise, let me know. Normally my headphones work really well, but maybe not today. So global privacy control, this is a really big topic of conversation for a lot of our clients. So you have these standards of opt-out preference signal, OOPS, or in some states they call it universal opt-out mechanisms. But effectively, when a consumer visits the website, the browser can be preset with a signal or a plugin. So when they land on the site, they're expressing a preference to that website through the browser that says, don't sell, share my data. It's an automated opt-out process. So like Google Chrome doesn't have it native, but there's a plugin for it. Some other browsers have it natively built in. This has got a lot of attention with Sephora a few years ago when a GPC signal was presented. It was not being honored. Now, in a lot of CMPs, it's really simple to honor those. It's effectively a checkbox that you put onto like a geolocation rule or a consent settings when someone visits the site. So you need to make sure that's checked. So when someone visits the site, now we're seeing, in addition to, hey, we need to honor GPC, we've seen some notice that we need to present the fact that the GPC has been recognized. So we'll actually want to have a pop-up that says, hey, we've noticed you presented the GPC signal, we've honored it, and actually give a visual representation to that. So these CMPs can tackle that. Where this becomes more complicated for organizations, and I kind of alluded to it earlier, is when it comes to an authenticated state for the site. So if you have a website that has a login to it, well, you move from an unauthenticated state for the customer, hey, some random number visited my website. I don't actually know it's Nick visiting the site. So when I get a GPC, sure, I'll turn off cookies. But I don't know it's Nick. I don't know it's his email. I can't actually opt them out of any downstream sharing because they're unauthenticated. The second I become authenticated and I am expressing those preferences, comes from a GPC or an opt out, well, now we have that obligation to actually take that known state to that user and then pass those downstream opt outs, effectively like an automated DSAR request in a sense. So, this is where things are becoming a lot more complicated for website owners because we need to um, identify that authentication. We need to identify what is that ID for that consumer that you're capturing. How do we capture that data for that opt-out signal? And where are we going to pass this downstream? A simple way that I've seen it is we have an authenticated user, let's automatically just submit a DSAR request on their behalf and fulfill it that way because we already have a process today internally for opting out of selling or sharing from my DSAR form. Let's just put it in that same workflow to fulfill it. Now I have customers where they want to more fully automate that process. So when we get that request, we need to pass that to the CDP. So a customer data platform that our marketing team is using. And that CDP is what is driving and determining what emails, what campaigns to send to a consumer. We need to potentially update that in a CRM and say, hey, we got this request signal. And so any tools that are looking to the CRM to see if we can contact them, we need to pass that downstream. So all that work is possible and we're building for that for our customers. But with OOPS and universal opt-out mechanism, specifically Connecticut is being aggressive in this space. The Connecticut Attorney General at the end of last year put out a notice saying, hey, you need to honor these GPC and universal opt-out mechanism requests that is driving a lot of this work and updates inside of a lot of legal compliance programs here. So that kind of sets me up for this next piece when it comes to Google Consent Mode. So with Google,
Actually, Nick,
yeah,
I mean, don't mean to interrupt. Can I jump in and close the loop on a couple
absolutely.
areas there? All right, great. So one, just to reinforce in a very important point you made, which is that, look, the way these laws are written is they're not the opt-outs and things like that are not intended to be specific to a particular browser or mobile application. The opt-out, the request to opt out of the selling or sharing of your personal information to a third party, or sharing for targeted advertising purposes, that's supposed to be holistic to the consumer. So if you receive a request as a business, you're technically not supposed to apply it only to that browser and call it a day. You're supposed to propagate that out to all of the consumer data touch points that that consumer has with your company, whether you're selling offline data, you're selling email lists to a third party for the third party's own marketing, or, other advertising that isn't, like, well, I guess you get a request, a GPC request through a mobile application. And as Nick was saying, you need to technically honor that through the mobile application as well. Once they become a known consumer, to use the CCPA regs terminology, but that you see elsewhere in other laws, is that you're supposed to apply it across the board, not just to the one sort of fragile use case, as one of the commenters who asked us a question in the chat, which we encourage you to do, said. So that's one point, and we're seeing a lot of companies kind of struggle with this, and you're seeing even in the enforcement actions now, at least one for California has said, like, you need to sort of honor it holistically. The opt-out is across the board, not just with respect to the particular, browser or app. The other one is that the GPC, it is or OOPS or UOMS, it is becoming much more widespread in these laws. It's now accounted for and required by California, Colorado, Connecticut, Montana, Texas, Delaware, Oregon, Nebraska, New Jersey, and Minnesota. With most of those already being online, Delaware and Oregon don't take effect until January 1st, 2026. So really only in about 4 months. Minnesota's just took effect the end of last month. Nebraska and New Jersey's, theirs are sort of odd the way the laws are worded, because you actually only find support for GPC indirectly in relation to authorized agents being able to request or submit privacy requests on behalf of a consumer. So it's sort of an odd way to get there, but that's how it is. And New Hampshire's took effect earlier this year too. So point being, widespread, not just California, Colorado, Virginia, Connecticut. We have many states now where this is a reality, and most of them at this point are outside the cure period afforded by the law. Not all of them, but the point being, you want your company to work with your CMP, if you're working with one, on getting this right for the different states, and making decisions as to whether you want to apply it to everyone versus just those who have a state that requires it and conversations like that internally. So just wanted to close the loop on that. Please, Nick, take it away on Google Consent Mode.
I love it. There's so much going on. It's like so hard to keep track of it all. And that's where I think you're probably seeing too, Darren, with your clients is what's the baseline we can take? So I don't have 20 different rules for 20 different states on how we're managing that. I'd be curious, and I'm sure it depends because you're an attorney, I'm a consultant. We'll always say it depends, but where are you seeing some of that baseline being set for customers on? Do we offer GPC to every state? Even the ones that don't require it today, because hey, we know likely in the future it's going to get there. Or are you seeing folks strictly staying with, hey, we're only looking at the states themselves, and that's where we're going to offer these rights?
Yeah, and it's in brief, it's a mix. Like depends on the risk tolerance of the company, depends on how widespread their business is. I have worked with companies that do both. Sometimes they say, you know what, I don't want the headache of operationalizing this across 20 different privacy laws, 50 different states, whatever. Let's just do, you know, frankly, not enough people even know about this outside of the privacy community to have this be a appreciable impact on our marketing and our ability to retarget and things like this. And so just afford it to everybody and we'll be done with it. Whereas other companies say, look, you know what? I only want to do what I have to do. And if we have this CMP, this other tool that will allow us to effectuate it only where we need to, then let's configure it that way. Let's provide the support and training for the individuals who are responsible for this, who have the clear lines of responsibility, and make sure they know how to set it up. And let's reinforce it by testing and things like this, where, then they approach it that way. They only offer it to the states where it's required. So it's a mix. Your mileage may vary, but whatever you decide as a business, you want to make sure the technical systems are following through with what you think they're doing. And so that's where, Nick and others, Nick and Ben and others come in to help you tighten up that ship and make sure you're doing it right.
Yeah, we see very similar. It's a mix. I wish there was like, this is what's happening, but it's definitely kind of split. A lot of it too, I think, depends on how does the business make money, right?
Sure,
And
sure.
if the business is purely B2B, they're just, their website is just a landing page. Like, okay, let's just keep it simple. But if it's a revenue driver for them, they're doing a lot of advertising. And if folks start to opt out that don't need to opt out, well, they could potentially lose out on ad revenue. That's where I see some considerations there.
Agreed. If you're a content publisher of news articles and stories, GPC catching on is much more, I won't say existential threat, but it's much more of a threat to your business model because if and you're watching those state bills like in California and elsewhere that are seeking to mandate that web browsers offer support for global privacy control and other sort of opt-out preference signals as a default so that they just turn it on once and it's broadcasting that signal out from the web browser to all the websites. And if something like that starts to take hold, then I think it will be more of a problem for companies to deal with. The first couple of years of GPC, and now that it's being supported by enforcement actions, as you mentioned, it's catching on, but it hasn't been such a drag on marketing teams that it's been a big difference. But I think as time goes on, that will continue to change.
Totally agreed there. When it comes to uh, a lot of organizations use Google Tag Manager and using Google Analytics. What was introduced recently in the past few years is Google Consent Mode version 2. So this is kind of Google's way to still help you collect analytics, but allow you to more respect the consumer's privacy. So it'll do still measurement, behavioral modeling, but the idea is we're not going to do that deep profiling that's happening without it. And so this is something that when you look at a CMP implementation, really understanding the tech stack of your website, of what options are available to you, and what are the initiatives and goals that your marketing teams are looking to accomplish with what's been implemented. Like I've had a client that's maybe a mid-sized law firm. They're like, yeah, we have Google Analytics, but no one looks at it because that's just not how we drive our business. Our website is it's just there because we need to have a website. But I have other customers that live and breathe what's going on inside of Google Analytics. Maybe they're a retailer, online retailer, clothing retailer, and when you put a cookie banner, a CMP on the site, well, that starts to impact your analytics, and that's where they make business critical decisions. So this is a step as part of the implementation that we always like to make sure that we offer to clients. Hey, do we want to enable Google Consent Mode? Here's the considerations. Here's the pros and cons of it. So you can have a stable um, overall kind of implementation when it comes to the web here. Now, this ties a lot into, well, did we implement it correctly? And is it being maintained properly? And that's where we look to tools like Bravado to come in and do regular audits and scanning to understand, uh, has my tag manager been maintained? Are we still, um, how much daisy chaining is happening? Because that is a big problem that you've brought up, Darren, here is once a tag comes onto the site, oftentimes that invites others tags onto that site that aren't in your tag manager at the time. They're actually just built into a third party that brings it on for additional analytics there. And so being able to do that audit, to understand if consent mode's firing properly, to understand what other tags are there, and to make sure things are being tracked and maintained, having an additional tool resource like this, we're finding is really critical to a lot of our client success here.
We got a question from Gail asking about how several EU regulators have said that Google Consent Mode does not fully comply with the e-privacy directive. Um, Apparently, CPRA does not have an equivalent. Darren, do you know what the California AG is saying about Google Consent Mode?
Yeah, it's not saying anything about Google Consent Mode. Google Consent Mode itself is oriented towards EU compliance, but I mean, and not to not singling out Google at all, but since they're mentioned here, we can note that there's also restricted data processing, which is a special feature that is set by default for some Google products, and or that must be activated for other Google products, and has to be supported by, in some cases, breaking the chain, for instance, between information collected via Google Analytics having a direct line to Google Ads, for instance. But the short answer being, like, generally speaking, what the regulator is saying is you have to honor, you have to support this you have to support opt-outs technically. And so we had in one case involving a medical information and health advice website, the California AG said that the CCPA and the state UDAP statute, the Unfair and Deceptive Acts and Practices, we call the unfair competition law in California, was violated because they failed to opt out consumers of sharing their personal information for targeted advertising. The law gives you an opt-out right, and the business didn't honor it, and they didn't, including through requests submitted by Global Privacy Control, to Nick's point there a moment ago on the previous slide. So that was an issue. You have in also in California, the AG and the LA city attorney in a case last year involving an app that pertains to SpongeBob SquarePants, went so far as to say that one of the injunctive relief provisions in that settlement was that you have to set up an SDK governance framework. We need you to identify each software development kit, in this case, a child-directed app. So what's the name and the third-party provider? What's the purpose of each SDK's use? Evaluate the configuration settings and the controls for each SDK's collection, use, or disclosure of personal information. Look at the contracts you have in place with the third party providing the SDK. It could go on, but that's what we're seeing. So the law itself and regulator, the California regulator hasn't explicitly mentioned Google consent mode, although in the Healthline case, or some of the cases that we've had, there is reference to one of the digital advertising self-regulatory industry bodies tools here, and how it wasn't correctly configured by the website in relation to CMP. So, you're seeing this in drips and drabs coming out of the enforcement actions where they're saying, hey, this is actually a priority. There's a lot of stuff in these laws, but we keep coming back to, in like the 4 cases that we have, we keep coming back to the same issues around not supporting opt-out signals, not, effectuating opt-out requests that people think they've submitted because of a misconfiguration issue with the tool, things like that. So there's a critical mass, I would say, now on how they're viewing this, and how they're signaling to industry, like, hey, you got to get this right. All right, and so briefly here, other use cases, there are other laws that are involved here. Not just the CCPA or the other state privacy laws or the EU GDPR. We have certain state wiretapping and call recording statutes where, at a high level, effectively, you have state and federal laws that set notice and consent requirements in relation to conversations and things that the laws were designed so that the government and private individuals couldn't tap your phone line, listen into your conversations. But as I mentioned before, the plaintiffs' bar has gotten very creative in trying to take legacy laws, like the California Invasion of Privacy Act that was enacted in 1967 in response to government abuses. And they're trying to take that law and take modern internet technologies and say, hey, having these third parties on your website for whatever purposes they're doing, if you don't get explicit consent and provide notice to individuals that they're there, you're violating the wiretapping statute or the call recording statute for the state. You invited a third party on and you didn't get consent. So we have about 12 to 14 states, depending on how you interpret the court cases in those states, that are called all party consent states. Each party to a conversation online or on the phone or otherwise must be provided notice and consent to the recording of their call, the sharing of the making available of the contents of the communications to a third party. Whereas the other states, say 38 other states, are single party, one party consent states, where actually the recorder of the call is the only entity that needs to provide the consent. So what you're seeing is the plaintiffs bar in all these all party, two party consent states filing lawsuits seeking settlements or threatening to go class action litigation against companies for using certain analytics technologies and other tools on the websites. One of them is session replay scripts, which is really an analytics tool that allows you to put it in your mobile application, put it on your website, and it will create a recording or a reenactment, more likely in most cases, or heat mapping of mouse movements, clicks, form submissions, what you typed into a form field, although it obfuscates certain information like credit card information, usually if you set it up that way. And it allows for A/B testing and debugging and fraud prevention and a number of other things involving user experience and understanding your consumers and how they engage with your digital properties. But there were a lot of lawsuits over the last 3 years on this, talking about, hey, this is a third party, you're intercepting our communications. You didn't ask for consent to use this tool, and therefore it's a violation of the wiretapping statute for the state or the call recording statute. And so that's what we're seeing here. And a lot of companies have had to deal with this, and a lot of companies tweaked their CMPs or signed up for a CMP to account for this. But as we mentioned earlier, it's not one-to-one with complying with the CCPA or things like that. And session replay is one area, chatbots is another, and pixels and things like that is one more. So we'll go to the next slide, please. And we'll say, another area, big area, VPPA that we mentioned earlier. This is where effectively you're providing video title information to a third party without consent, and you have to be a videotape service provider. There's definitions of that. We have, class action fines are possible, punitive damages, attorney's fees. You've seen a real spate of those. Social media pixels, this idea, particularly when you are sharing, arguably sensitive information like health conditions in the name of a custom audience segment or something, that you are sharing as part of as a conversion or something with a social media pixel that then shares the information with, for ad targeting on the social media platform. This has been a huge area of, shakedown letters and settlement requests, things like that. And so we're still seeing them. There's different flavors of them, but this is an area where you really want to be on top of it. If you're using any of these, use pseudonymous information instead of a health segment. Don't call it the video title. Use some other thing where on the back end what it refers to, but you don't share the title of the video that they watched with a third party. Things like that are minor tweaks that actually can be quite prophylactic. We can go to the next slide, please. And yes, finding the right balance. And hand it over to Nick for that.
Love it. Yeah, there's obviously a lot of considerations as you set up a CMP. How do you manage this? And it can definitely be overwhelming if you allow it to be. And how we like to look at it is a few different pillars. So why are we doing this? Sometimes it's just a fundamental question. This is what I tell my team when we walk into an implementation. Why is a client wanting to put a CMP onto their website? Is it because, hey, we got a SIPA notice and we need to get compliant really quickly, and that's what we're going to build to solve for today? Or maybe we're looking to expand and go into other regions, move over into Europe and expand into GDPR, where previously, that was never in scope for us. We recently did a CMP and a DSAR consumer rights implementation for a casino out of New Jersey. And they only operate in New Jersey. They don't advertise outside of it. And they got to ignore the past, 8 years of all this compliance stuff. Now, until now when New Jersey enacted their own state privacy law. And so having that context really helps us determine, well, what is the right approach to implementing? What are we really looking to solve for here? So first, what's that user experience? We don't want to break the core functionality of the website. It's some CMPs you can put on a site where they're potentially dynamically blocking scripts on the site and not going through a tag manager. And that's where you'll find images no longer load, or maybe a checkout page is accidentally being blocked because it's coming from the same core script that's being loaded on the site. So we want to make sure we're not breaking anything that is core functionality of the site. We want to understand what's this impact from a metric standpoint. Well, what are the analytics we're getting today, being able to track and understanding and communicating to our team members and other departments around analytics and marketing that a CMP could potentially impact our consent rates and the metrics and tracking that we're getting onto the website, especially depending on the type of consent model that we're deploying on the site. Is this an opt-in by default or an opt-out by default? Where's the majority of our traffic coming from? Maybe it's certain states that we're going to be a little more conservative in versus other parts of the US where we'll have everything free flowing and you can't opt out. And so understanding those baselines and really metricing against those. There's a part of this where it comes to what's the legal requirement that we're trying to solve for, but balancing that with where's this market going? And we need to think about, for our organization, what side of the fence do we want to be on today? Do we offer this to every single consumer, or only to consumers within the states that are impacting us from a regulatory standpoint? And one way that we've seen organizations solve for this is, hey, for certain states, we'll give them a pop-up notice, give them that banner itself to interact with. But for other states, we won't actually present the banner, but in the footer of the website, they could still interact if they wanted to. So we're giving them the ability to manage their consent, but we're not going to put a pop-up banner in front of them because today, we don't think we need to do that, but we still want to provide that, meet the consumer with their expectations, because I think largely that's where a lot of this is moving. For better or for worse, we'll see more consent notices, more pop-up banners, because that's kind of the consumer expectation. And you can adjust to that. That's a good thing about a lot of these CMPs is, hey, our decision today, if we want to have only a pop-up in California but nowhere else, but as certain states and regions come online, we want to adjust that. You can update that inside of the CMP, publish a change really inside of your tech platform itself, and that propagates downstream. But a lot of these challenges really don't come from the tech. They don't come from kind of the legal decision. It comes down to, what is that implementation? Did the implementation, was it a correct implementation? And how is it being maintained long term? We recently went live with a CMP for a multi-billion-dollar company, and March, everything's categorized properly, but had no tag governance. And today, new tags have been added to the site and not being blocked properly because internally the governance wasn't there and the audit, the ongoing review was not taking place. And so that's where we look to tools like Bravado to say, hey, we went live, but we need to maintain and manage this moving forward. Our marketing teams probably aren't even the folks putting tags into our tag managers. A lot of marketing teams use third parties to manage them for them. So they're submitting requests to a third party. That third party says, yeah, sure, I'll stick it on. And they're not even looped into a governance framework here. Very much wild, wild west when it comes to some of these tag governance situations. And so that's where we want to understand and be able to flag issues and get them resolved in a timely manner here. And so that brings me to really this governance side. So how often are we scanning? How, how often do we expect our websites to change? What is our response to any issues that are coming through? How are we tracking and managing that? Do we have proper documentation in place? And Darren, I have a question for you this. I know we're running out of time, but documentation, what are our policies? What are our procedures that we can look to and say, hey, are we following this? We can also go back to a regular and say, hey, this is our process. We're following it. And maybe something fell through the crack, but we do have a plan in place to manage this. We also want to conduct regular tag management audits. You want to also look at the website as itself, because not every cookie or tag goes through a tag manager. You can deploy this directly on the website. It can come through a third party. Understanding who the vendors are, who are we contracting with to provide these analytics services. That now starts to fall into your third party risk management program as a whole. And then ultimately, I think you should put together some sort of steer co when it comes to your website and changes on that site. So if you want to add something new, do we know who it's from? Do we have contracts in place? What's the purpose of this new tracker or tag going on onto the website? How long is it going to live for? What happens when this website gets deprecated? Because a lot of folks probably on this call, marketing team spins up a campaign site or a sweepstakes that's good for 3 months, but that website never dies. And so we're continuing to track, and that just expands our exposure because we have these trackers and tag managers that are no longer being maintained, but could still be capturing information that we're not using. So let's have a good process in place to really deprecate some of this. Darren, my quick question for you, and I apologize, we're out of time here. We probably have like 20 more slides to get through, so we won't get through them all. But I think this is a good question. When it comes to our tag management and like scanning, something comes onto our website, is having a really clear documented policy, is that a good practice for us to have? I think it is, but because something's going to change, and I can't monitor the website every second to make sure something bad isn't going on. But if I can say, here, my policy is to look once a month, and if I see an issue, I resolve it. Can I use that and say, Mr. Regulator, Miss Regulator, I understand it was outside of my monthly scan, but once we identified it, we resolved it. Is that a sufficient practice? Do you see that? Do you recommend something like that?
Absolutely. Anytime you can offer evidence to a regulator that you have given this thought, that you did approach it proactively, and maybe there was an inadvertent oversight or implementation breakdown, but that you meant to do it the right way, that carries a lot of weight. And so I recommend having, tying together your vendor questionnaire, so how you're evaluating, individual companies that may have their tracking technologies on your website. Having teams who have with clear responsibility, making sure you have, check boxes in terms of the contracts that you have in place, whether it's a service provider agreement or a third party contract. There are certain requirements under the California Consumer Privacy Act for contracts with third parties, even that you don't have in the other states. So yes, having sort of a checklist that you can provide your teams whenever they're thinking about putting a new tracking technology on the website, including requirements around how often you scan the sites or the apps, who's responsible for categorizing them, things like that. That's really key, and it will get you halfway to happy hour. And I guess the next practical implementation, yeah, I think we talked about these, and you'll provided these slides, as something to sort of fall back on. But scanning, identifying, categorizing the right way, having the right people involved, knowing the contracts in place, and describing things in your privacy policy. That's kind of the name of the game. If you can do the things on this slide, these core areas, you will be in strong standing to withstand informal investigations or more formal investigations from regulators or the plaintiff's bar under some of the state laws that have a private right of action. And same thing with the practical consent interface design. On the next slide, these are the things you want to be mindful of. It gets to the dark patterns that we talked about. It gets to being friendly for the particular environment you're in, whether mobile or desktop. It's giving controls to people, granular controls, being clear in your documentation and your privacy policies as to what you're doing, and making sort of following the golden rule of doing what you say you're going to do and not doing things you don't say you're going to do. And then we can close by Nick and his team put together kind of a quick set of slides on what this looks like if you're using, for instance, the developer tools within the console of your web browser, and you have slides and arrows that can point you to that. And maybe that takes us to our last slide on key takeaways and considerations, just sort of reiterating what we were talking about here on the key things to get right. And if you can do that, then I think you'll be in strong position to have a strong privacy program and do right by your consumers. Any final thoughts, Nick or Ben, as we're at time?
Yeah, thank you so much, Darren and Nick. Yeah, we had a lot to go through today, and yeah, a very thorough presentation of the whole issue around consent management, managing privacy risk, governance on websites and apps, and on all the different requirements and considerations that go into play. So, yeah, I think we can all, from today's presentation, there's a big need to have this oversight over consent management on websites and apps. Privado provides automated solutions to do that, to audit websites and apps to ensure that CMPs are implemented correctly. There's certain things that fall outside the CMP. For example, there's sensitive data sharing that should not be shared regardless of consent. The CMP could be, there could be tags firing before the CMP even starts. So there's a lot of things that need to be audited outside of just the CMP. But yeah, thank you so much for the presentation to everyone. We will share the slides and the recording. We have an upcoming webinar next week regarding the new state privacy laws in Maryland, Minnesota, and Tennessee that I recommend everyone attending. We have two privacy lawyers presenting on that. Otherwise, yeah, thanks again for attending. If you're interested in getting your website audited or app audited, please contact us at privado.ai. We can set up a free audit or consultation, and you can ensure that your website or app does not have any privacy violations. Thanks again, Darren and Nick. Any last final thoughts?
Thanks, Nick. Thanks, Ben. Thanks, everybody.
Thanks, everyone.
All right. Thanks again. See you next time.